I look forward to discussing this more. Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
No.
I'm
if they're
talking.
Not privileged,
quiet.
Don't yell at me. If they're not
Mr. Chairman, would you stop the clock? This is on your time. It's not on Mr. Goldman.
They're not
Even though you used your improper redactions.
You'll like my answer.
To continue to protect
privileged,
time belongs to the member.
We'll be happy to release them.
We'll stop the clock. We'll stop the clock. Time belongs to the member. Go ahead.
What you just watched is the Attorney General of the United States refusing to answer a direct question from a member of Congress about documents her own department is legally required to release. Not complicated legal theory, not a gray area. A federal law was passed requiring the release of the Epstein files. The president signed it because he had no choice. The majority against him was veto-proof. And Pam Bondi is still sitting in front of Congress saying one word over and over again. Privileged. Tonight, a document long buried inside the Jeffrey Epstein investigation was read aloud in the halls of Congress. It names names, it exposes coordination. It places the highest law enforcement officer in the country in the direct path of a perjury investigation. This is the document the Department of Justice did not want the American people to see. And tonight, we are going to go through exactly what it says, what the law requires, and what accountability now looks like.
New York recognized.
Thank you, Mr. Chairman. Ms. Bondi, I went over to the department yesterday for a couple of hours to review some of the unredacted materials. And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents. An 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those two documents in unredacted form to members of Congress? Not a complicated question.
Well, I guess it is for you because you have a law degree and those are privileged.
Let us be precise about what Goldman just described. He went to the Department of Justice. He spent hours reviewing the Epstein files. And what he found, and more importantly, what he did not find, tells you everything about what this department is hiding and why. The client list Bondi publicly stated was sitting on her desk a year ago was not there. It does not exist in the materials available for congressional review. A senior member of Congress went to the building, sat down, and looked. It was not there. What was there and what is still being withheld from Congress is an 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Epstein's co-conspirators. These are not administrative documents. These are the foundational materials of the entire investigation. They contain the evidence prosecutors weighed. They contain the names of the people prosecutors believed were involved in Epstein's criminal network. And they are still redacted, even for members of Congress, even after a law was passed requiring their release, even after the president signed that law. Bondi's answer was privilege, but privilege does not apply to a prosecution memo. It does not apply to a draft indictment. And it does not explain why the names of co-conspirators in a child sex trafficking case are being protected by the Department of Justice, while the names of victims are left fully visible.
Okay, they're not privileged, but we will discuss that later. I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted, and it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you
were
unredact
lead
this?
counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course.
That single word, privileged, is now the most legally consequential word spoken in that hearing room. Because Goldman just explained on the record, in front of the committee, exactly why that privilege claim is wrong. Attorney-client privilege protects communications between a lawyer and their client. Jeffrey Epstein was not a lawyer. Ghislaine Maxwell was not a lawyer. An email sent between two co-conspirators in a criminal trafficking network is not protected by attorney-client privilege under any reading of the law. The crime fraud exception exists specifically to prevent privilege from being used as a shield for ongoing criminal conduct. Bondi is the Attorney General of the United States. She has a law degree, she knows this, which means her privilege claim is not a legal argument. It is a deliberate choice to keep that email hidden from the American people. And the reason it needs to stay hidden is sitting right there in Goldman's hands. An email from Jeffrey Epstein to Ghislaine Maxwell containing notes of statements Donald Trump made about his prior relationship with Epstein. This is the document the Department of Justice did not want Goldman to find. This is why nearly half the required documents were withheld. This is why the prosecution memo is still redacted. This is why the draft indictment is still redacted. Because somewhere inside those documents is a full picture of what the president knew, what he said, and when he said it. And the attorney general he appointed is using the word privileged as a one-word wall between that picture and the American people. Let us also address the perjury question directly. During her testimony, Bondi stated under oath that there was no evidence of criminal activity by Donald Trump in the Epstein records. If the email Goldman found contains statements that contradict that testimony statements made by Trump himself about his relationship with Epstein, then that sworn testimony becomes a material false statement. That is the legal definition of perjury. And it is why Goldman and Ted Lieu have formally requested that Deputy Attorney General Todd Blanche appoint a special counsel to investigate Bondi's testimony.
Even though you used improper redactions to protect Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. One is redacted, 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims. Now, in an interview last week...
How will you tell me that's intentional?
In an interview last week, Deputy Attorney General Todd Blanche...
You can't go off script.
...said that any victim that wants to speak with the department has done so, hopefully. Well, thanks to the incredibly brave people sitting here behind you, we can actually ask them if that's true. Now, would the survivors and victims who are here please stand up one more time? Just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and estimate and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence?
That moment in that room is the one that cannot be explained away by any privilege, claim, or legal argument. The Department of Justice had the resources to track a congresswoman's private search history inside the Epstein files within 23 hours. They had the staff to compile opposition research binders on members of Congress before a hearing. They had the time to carefully redact one name out of 32 on the Epstein victim list while leaving all 31 victim names fully visible. But they could not find the time to meet with a single survivor who reached out to offer evidence, not one. Every person in that room had contacted the Department of Justice. Every person in that room was denied or ignored, and every single one of them is still willing to talk. Deputy Attorney General Todd Blanche told the public that any victim who wanted to speak with the department had already done so. That statement is now sitting next to a room full of people who raised their hands to say the opposite, on camera, in front of Congress. This is the department that Pam Bondi says is protecting law enforcement and serving the American people. These survivors are the American people, and her department will not meet with them.
All of them. And of those of you, all of you, who have reached out, how many of you were denied or ignored by the Department of Justice? All of them. And despite the shameful and despicable efforts by Ms. Bondi and her department to intimidate you, how many of you are still willing to speak to the Department of Justice? All of them. Well, Ms. Bondi, it looks like you have some more witnesses
Gentleman's
to
time has
talk to,
expired.
and I yield back.
We will go to the good gentleman from North Carolina, Congressman Knott.
Thank
May
you.
I have a moment, Congressman?
Yes, ma'am.
Thank you. Here we go. Here's the photograph. This is why he wanted to repeat everything that had been said previously on Epstein. This is his state, New York. You probably don't even know who this is. Wahid Mohammed from Afghanistan.
Yes, because I'm no longer a prosecutor.
Convicted of assault. Wow, he represents New York. Wow, yet he doesn't care about the illegal aliens convicted of crimes. Assault and homicide. No longer a prosecutor, so he doesn't care about his constituents. Here we go. Arson, El Salvador, Miguel Palacios. Fermin Flores Ramales, Mexico, rape.
Let's talk about the 70% of immigrants who are detained without a criminal conviction or arrest.
Stop the clock. Stop the clock. Time belongs to Congressman Knott.
This is Bondi's strongest defense. So let us dismantle it completely and finally. The existence of violent criminals does not remove the Department of Justice's legal obligation to release documents that Congress passed a law requiring it to release. These are not competing priorities. The Department of Justice employs tens of thousands of people across hundreds of offices. It is fully capable of prosecuting assault and arson while simultaneously unredacting an email between two convicted criminals that contains no legitimate privilege protection under any statute. Bondi did not cite a single law. She did not invoke a single privilege that actually applies to an email between Jeffrey Epstein and Ghislaine Maxwell. She held up photographs of people who have nothing to do with the question Goldman asked. That is not a legal defense. That is the conduct of someone who has no legal defense. And here is the detail that makes the whataboutism collapse entirely. The same department that cannot find the time to meet with Epstein survivors, not one of them in over a year, found the time within 23 hours to compile a detailed record of exactly which Epstein files a congresswoman was, searching for and turn it into a political attack document for a hearing. That is where the department's priorities actually are. Not with the survivors, not with the law, with protecting the people in power from the questions they do not want to answer. Goldman and Ted Lieu have now formally requested a special counsel investigation. The committee has the emails in the record. The survivors have testified on camera that they were denied and ignored. The 86-page prosecution memo and the draft indictment are still being withheld in violation of federal law. The accountability process is moving, slowly, against significant resistance, but it is moving. And the one word Pam Bondi kept repeating in that hearing room, privileged, is now the word that a special counsel investigation will have to answer for. Subscribe, because the next 72 hours in this investigation will tell us exactly how far the protection of power in this country actually goes.